I'm Tennille.
And I'm Kelsey, and we're financial advisors from Allman Partners True Wealth, bringing you thought-provoking conversations around you, your money and your life on the Wealth Experience podcast. So welcome back everyone to the Wealth Experience podcast, and today we have new guests joining us for today's conversations, Leanne and Joe from Pearson's Family Law, a law firm based in Melbourne, and we're going to deep dive into matters of family law and in particular pre-nups, asset protection, property division and settlements. And there's quite a lot of content today, but no doubt some really, really interesting things to uncover from the experts. So without further ado, Leanne and Joe, welcome, and thank you for taking the time from your busy schedules to have a chat today.
Thank you for having us. We're excited to be here.
Thank you very much for having us.
Very good. And I thought we would just start by just getting a quick overview of who you are, what do you do, just so our listeners can get a bit of insight.
Sure. So Joe and I are business partners, not life partners. We're married to really nice people, not each other. And we've both been practicing for 4 decades now. And so we're both directors of Pearson's and love the firm. We're leaders of a firm of about 35 people, and our specialty is family law. About us, so I'm married with 3 kids, and I was an Irish dancer for many decades, very unusual for a European girl, and I'm a twin with 4 brothers, and that's probably the most interesting thing about me. Joe?
I grew up in country Victoria up north, Swan Hill, up on the Murray River, and I am one of 5 siblings. I am the middle child, therefore I suffer from the middle child syndrome. And I've got a passion for family. I've been doing it, as Leanne said, for 40 years, and love my job and love what I do.
Wow, so that's a lot of experience between the two of you, and you come from big families, both of you. So I wonder if that is somehow influenced your decision to come into family law. But yeah, thank you for sharing, and it gives us a good insight a little bit as to who you are and what you're about. And it's great to hear that you love and obviously are passionate about what you do. And I think that really aligns to what we do at Allman Partners in our business. And I guess the aim of the podcast is just to educate and inspire people in all things that have relation to financial matters. And of course, family law is certainly intertwined with that on occasion too. So it's obviously a very complex area, and no doubt would come with a lot of heightened emotion. And I think there might be a little bit of a misconception in this field, and I'd really love to hear from you guys before we get stuck into the nitty-gritty of the topic areas. What is the biggest myth about family law that you wish people understood?
I think, I think what has happened over the last few generations is that people's lives have become very complex. So their personal lives are complex, with blended families and lots of different things that now happen in families that didn't happen previously. And I think their financial lives are really complicated as well. And I think that I guess there are 2 biggest myths that we come across. One is that you have to have lived together for 2 years to be de facto. And once you've lived together for 2 years, you're in a de facto relationship and the other person's going to get 50%. That's myth 1. And I think the other myth 2, which would probably resonate with many of your listeners, is that if you put assets into a family trust, well, they can't be divided. They're probably the 2 biggest myths. What do you think, Joe?
I agree with Leanne that lives have become far more complex, particularly financially. When I started doing this 40 years ago, most people had a house, a car, 1 job, 1 bank account, 1 credit card. Now people have multiple houses, multiple investment properties, loads and loads of bank accounts,
Credit cards.
Their financial lives are very, very complex in the main. And I think that the myth that goes with that is that people think that lawyers are there to make their lives complicated. And I think that that's not true. Lawyers are there to help. And we can unravel that with experience. Our job is to make things easier, to get down to the nitty-gritties and get down to the bottom of what is really there, flesh out the bones, and then work out a solution and help people come to a solution. Like Leanne said, people have got misconceptions about what's in the property pool for division. Property in trust is safe, so it's protected. well, that's not true, we can tell them that's not the case and why that's not the case and how it's most likely going to happen.
Yeah,
Yeah.
and I think the biggest role that you play as part of the process is the education piece and helping people understand, what can you do when you're in certain situations, and perhaps then what can you do before you may get into a certain situation. So I think that naturally we're going to have those conversations today, and I'm sure you've got some really good tips and tricks and information in that area. So let's perhaps just get stuck in, and you just touched upon it there around the matters of settlement and property division. So in terms of the steps that the court considers when they're determining a property settlement, what are those steps? How does the process work?
So can I just jump in there? So when clients come to us, we talk about what the court will do. We don't go running off to court. That's another myth. Lawyers don't go rushing off to court. We try and avoid court like our clients try and avoid court. But what we do is we look at what would the court do in this situation, and we use that as an example of how we're going to approach a resolution of their matter, their individual and particular matter. So in a financial matter, for example, the court goes through a very specific 4-step process. And the first step is to work out what is the property pool, what's available for division between this couple. The second step is to look historically at contributions, what each of them brought into the relationship, what they each contributed during the relationship, although that's really not so significant unless there's something coming in from outside, such as a gift or an inheritance. And then the question is, when did it come in? What did they do with it? Things like that. Then the third step is for the court looks through its what I call crystal ball to see, is there any reason why the property pool needs to be adjusted so one party gets a bigger piece of the pie upon a property settlement for future needs such as health issues, having dependent children, the need to house a child, income differentials, things like that. And then the last thing is the court then works out what it would do as an adjustment between this couple, and then to see what will be a fair division of property and resources. And property includes superannuation, of course.
And that's one of the myths. You talked about what's a common myth. That's another myth that a lot of people think, well, hang on, that's my superannuation. I went to work. My employer gave that to me. Surely that's not included. Yeah, that's included. So whether it's in the accumulation phase, whether it's in the pension phase, for example, if you're a defined benefit, that's included in the property pool.
Yeah.
And as I said, family trusts. A lot of people come to us and say, yeah, but that's in a family trust. My accountant told me to put in a family trust. So particularly in second relationships, so that she or he couldn't touch it. Well, that gets included in the family, in the division of the assets. That's part of the property you throw in to be included. So it's everything. It's cars, crypto, shares, real estate owned by a company, real estate owned by a family trust. And you're really looking at who the puppeteer is, who's in control of that property or that asset, even if it is in a family trust.
Yeah. I mean, you must have people that, quite frequently are, in the midst of a divorce and say, can't you just set up a trust and tuck it away in there, or, making changes during the process as well. And then we can talk to that point. I think there's a bit of a misconception around that as well, that you can kind of do anything at that point in time when you're going through the process. Now, Jo, you'd mentioned that the court will decide what is a fair division of the assets. So how does the Australian family law system actually approach that? And you had also mentioned within that kind of non-financial contributions such as, homemaking, looking after the children, that sort of thing. So how does that all come together? How is that factored in?
So obviously the concept of fairness is subjective. I have never seen two couples walk out of a courtroom both saying, yeah, that was a fair outcome, I'm happy with that. Usually one party or the other, and mostly both parties, are unhappy with the outcome. So the concept is very difficult to put your finger on. But what happens is the court goes through that 4-step process to work out what the court considers just and equitable, and it's discretionary. So any particular judge will have their own view and make their own assessment about what weight they would give to things like contributions.
Okay.
And not only would they give it their own weight, of course, you've got many, many judges, let's say 100 in Australia. Most judges will make a different decision on the outcome of any particular given fact situation put to them. But what
Yep.
we do with clients is you can work out what's called a range. So, given these factors, given your property pool, given the assessment of contributions and future needs, I think you're going to get somewhere between 55 and 60%. 60% your best case scenario, 55% your worst case scenario. So that's what we can negotiate around. You might settle for 53%, right? You might want 65%, but most lawyers should be able to narrow it down to that band of, let's say, 5%. And if you can get it to there, then you can sort of have some robust discussions about avoiding court, avoiding delays, avoiding the costs, avoiding the risk, because you don't know whether you're going to get up the higher end of your range or at the bottom end of your range. That's all the risk factors. So if you want to avoid all that, then all of it's just and equitable within that band.
Yeah.
From a commercial point of view, the risk associated with not knowing where in the range of that, say 5%, even if it's 10%, is going to sit can be absorbed in legal costs if you go all the way through the court process, various hearings, mediation. Often you say to a client, okay, every 1% you're arguing about is this much. Is it worthwhile? The stress, the unknown, the delay, because you get your court hearing, say within a year of you actual issuing proceedings, the wait can be up to a year. But once you have your day in court, you could be waiting another 6 months to get the decision. So that delay takes its toll on people. If you're self-employed, it can affect your ability to earn a really good income because you're under the microscope the entire time until the decision's heard or a settlement occurs. So it certainly has a human cost and a financial cost that people factor in when they're deciding to settle within the range.
Yeah. Yeah.
Often people put their lives on hold, waiting for this to be unravelled and finished either by way of agreement or court order, and don't get on with making other decisions in relation to their life, repartnering, buying investment properties, because they don't want to mix it all up in the history, if you know what I mean. And so therefore their lives are on hold. And most people make a value judgment about, well, that's a cost I need to bear and take into account in trying to resolve my historical issues so I can get on with my life.
Absolutely. And so what I'm hearing within that is really when you going through the court proceedings, that's the point that you're trying to avoid, and there's lots of steps before that. So tell us a little bit about those steps. So someone comes in and approaches you guys with regards to the divorce. So before you even get to court, and hoping that you don't get there, what is that process that you would go through with a client?
Yeah, so as Joe said, the aim is always to avoid court, but of course sometimes it's necessary to, either because there's an urgent issue on the table, such as financial support of children, financial support of a spouse who may not have been working, and the drip of money has stopped, and so they need to go to court to get an urgent order for financial support or to urgently restrain someone from disposing of an asset. So sometimes there is an urgent need to go to court. Eliminate that need, then your process is normally to get instructions from the client to then get a mapped picture of what they think the asset pool is, what the factors are falling into that 4-step process, and to then, first step, write to the other side, either directly or through their lawyer, if they don't have a lawyer, to them, saying, look, our client would like to settle quickly, efficiently, cost effectively, and amicably. This is what we need to start negotiating. And we ask for what's called discovery. Please give us 3 years of bank statements, your superannuation statements, trust account statements, company returns, tax returns, individuals, credit card statements, superannuation statements, a list of all the things that we need. Then we ask for a response, usually within about 21 days. Sometimes we'll give the other party another 7 days after that. And then we'll remind them that under the rules, they're required to give that disclosure. The next step would be to collate that information and, of course, to provide it to the other side as well from our client, and to get a more detailed picture. What's the balance? What's the superannuation? What's the asset pool that we're dividing? And then to put forward a proposal to the other side. And we normally do that in writing, saying, look, these are the factors that we think are relevant. This is our proposal. Please provide a response. If you think that the response is too far off, you might suggest a mediation where parties are negotiating confidentially and trying to reach an agreement, or you might negotiate somewhat further and to and fro with some offers. If you
Mm.
can't get anywhere with a mediation or negotiation, then you'll issue proceedings, and it doesn't matter who goes first in family law. Everyone pays their own costs, and you'll issue proceedings and start the court process. The first court process is what's called a mention, a directions hearing, where the court might say, right, value that asset, don't value that one, do this, discover that, and go to mediation. They'll always request the parties going to a mediation, even if they've already had a mediation. And then from there, it goes through various steps to get you to the final gate. If you can't resolve it, you'll have to have your day or days in court to get the umpire, being the judge, to decide.
Yeah. So it sounds like there's plenty of opportunity before you get to that point to resolve the matter, and both parties are given a fair go at doing so. Now, question for you within that, you may, I'm sure, have come across on occasions where people do not disclose certain assets, and they think that, I'm not going to mention this and they're never going to find out. Perhaps the said ex-spouse didn't know about that asset either, and it had always been a secret. Now, I'm sure that you have your means and ways of uncovering all these things, especially with everything being online now as well, with registrations and whatnot. What impact does that have when someone does that?
Well, we tell our clients, if it's our client who's got assets that they're trying to hide, we tell them that there's not much point in doing that, because if we reach an agreement and we don't disclose those assets, and I mean, if you're talking about a bank account with $3, then it's insignificant. But if you're talking about, some asset worth a significant amount in the context of that property pool, then when it comes to light down the track, if it comes to light, the other side can make an application to the court seeking that the previous property settlement be overturned because it was unjust and inequitable, because they never would have agreed to it if they had known about this asset that was hidden. And the court will readily overturn the previous property settlement. And not only that, then the matter will start off again, and the non-disclosing party will, one, be on the back foot about credibility. They've already lost their credit. And two, the court's going to be at large about exercising their discretion when it comes to dividing up the property pool. If it's become obvious during the process that there are transactions which can't be explained, and they amount to significant amounts, and they can be identified, and the non-disclosing party can't explain where those monies went or how they were used, and the court is persuaded that there must be something untoward happening, the court on many occasions has said in that situation it's at large to use its discretion to then give the disclosing or the innocent party a bigger piece of the pie, knowing that there's other stuff hidden somewhere.
Certainly, if a client asks, if we're aware of an asset and the client asks us not to disclose, we can't represent the client, because above all else, we are officers of the court and we cannot mislead.
Yeah.
So we send them off to another lawyer. We can't do that. But really, there's not much, as you said, Kelsey, that can be hidden, in the sense that it shows up on a tax return, doesn't it? Whether it's a dividend or whatever. I guess possibly crypto. But clients usually know if their partners have participated in crypto transactions, and that can be obtained. That information can be obtained from a hard drive or whatever. Or the casino. We've often had clients saying, oh, my husband will say he's lost all the casino. Oh, well, that's good. Let's get the footage. Because, there's cameras everywhere.
Yeah.
So how often does he go to the casino, or she go to the casino? What days? Because we can get the footage. We can subpoena that.
Yeah. Okay.
So
Yeah.
people do get unraveled.
Yeah.
Certainly do.
Yeah, and no doubt it doesn't stop people being creative with that sort of thing. So that's really interesting that you mentioned crypto, because yes, of course, it's not through all the normal systems. So yeah, but
during the court process, of course,
yeah.
one means available to the parties is that they can subpoena records from banks, Crown Casino, or any other casino or any institution. But unfortunately, that's limited to Australia. So if one party suspects that the other is hiding assets, then there's the avenue of issuing subpoenas for them to produce documents to the court that can be viewed and flush out something that may be hidden.
Yeah, so what I'm hearing is it's honesty is the best policy, as always, so that things, of course, don't get messy. Throughout these conversations, there was a question that kind of came to mind as well, and does the length of the relationship that somebody has affect those outcomes in terms of the division of the assets?
Definitely. Whilst the Family Law Act itself doesn't define the difference between a short relationship and a long relationship, the case law does. And the case law generally says anything that's, say, 5 or 6 years or less is a short relationship. Anything more than 5 or 6 years is long. And when you're looking at a long relationship, you don't need to forensically look at who paid for the groceries, who paid the mortgage, who did this, who did more of the cooking, who did more of the cleaning. It's considered to all be joint endeavour. The shorter the relationship, the more you can forensically look at what did each person start with, what did each earn during the relationship, what did their income go towards, who, all that sort of thing. That
Mhm.
probably is watered down or eroded, that sort of forensic exercise in a short relationship if there are children. Because it's obviously if there are children, one party might have given up some of their income or their career, and that might affect their income earning ability. So it's probably more relevant, shorter the relationship, with no children. It's a bit like, I always describe it to clients as an omelette. If that omelette's only been in the fry pan for a very short time, let's get those eggs back in the shell. But if that omelette's been in the fry pan for, say, more than 5 or 6 years and longer, well, no eggs are going back in that shell. It's just going to be an omelette, and we've got to divide it
Mhm.
proportionally.
Yeah,
Yeah.
that's a good analogy. So in thinking around then the protection of assets and anybody that might be, worried about protecting entitlements, whether they're in a, happy, stable relationship or, perhaps not so much, what's the first thing that they should do or think about? And this might be where, the binding financial agreements or prenups often comes to mind for people.
I think we might
That's
first describe it as between a couple, and Joe will go ahead. And then I
Mm.
think it's worthwhile describing it if you are the bank of mum and dad and you're giving the kids the money and you want to protect the asset, because that's a really big part of our work too. So,
Mm.
so. I mean, that's becoming a bigger field for family lawyers, as there's a bigger generation of wealth moving down from one generation to the next,
Mhm.
and the court put in place the mechanism of uh, people entering into binding financial agreements, which include prenups, which can be done either before parties start living together in a de facto relationship or before they marry, um, which then sets out the parameters of what a property settlement would look like in the event that they do separate. You can do a binding financial agreement during the relationship, that is, after the parties have started living together or after they've married, which again sets out what would happen in the event of a separation. Or we can do one after they've separated to affect a property settlement. You can also do a binding financial agreement to protect one individual asset. Let's say that the parents want to gift a house to the couple, but mainly to their child, obviously.
Mhm.
Then you could do a prenup that says that in the event that the couple separate, that asset is excluded from the property pool, and all the other assets could be looked at as if they were being looked at under the provisions of the Family Law Act.
Mhm. And how strongly would that stand? So if somebody, just in that example that you had given, the parents have gifted, if you like, the house to their child, but everybody's receiving the benefit from that, and they've got a binding financial agreement around that asset. How much does that stand in court if they were to separate?
If the agreement is done properly, and there's no, so a BFA is a contract. So as long as there's no what we call contractual grounds to overturn the BFA, such as duress, undue influence,
fraud.
fraud, all those sorts of things, as long as it's done properly and there's full disclosure, done well in advance of the living together or getting married, all those factors that the court would look at to taint a BFA. So as long as it's done properly,
Mhm.
both parties get separate and independent legal advice, and it's done in accordance with the provisions of the Family Law Act, which sets out all the requirements that are necessary, it'll be watertight.
Yeah. Okay. Yeah.
Want to invest your hard-earned money but don't know where to start? Allman Partners True Wealth presents AP Direct Invest, your online self-directed investment solution. Choose from 6 low-cost exchange-traded fund portfolios, including 2 socially responsible options. To manage your own investment experience, visit allman.com.au/AP Direct Invest and start your investment journey today. AP Direct Invest, your investment solution. Any financial product advice is general advice only and may not be appropriate for you. Always read the PDS.
So we often talk with our clients when we're thinking about financial planning, the intergenerational wealth piece. And like you said, there is a big shift of wealth at the moment. And we are seeing people want to do that earlier where they can, when they can afford to do such a thing, so that they can see the fruits of their labor and passing on some of their money. And there seems like there's kind of two ways that they can go to protect that transfer from other parties, and it's usually spouses that we're thinking about in these cases, in case there's a rocky time in their relationship, and they don't want to see their wealth then be eroded from their family and taken away. And we've kind of got binding financial agreements on one side, and then loan agreements on another side. So tell me a little bit about there's a third. Which one is the third?
The third is that, so you're talking about parents parents giving money to their children, right? The generational one.
Yeah.
So the third is going on title as a tenant in common in an equal or an unequal share. That is watertight. So if you give $200,000 to your child and her partner or his partner, let's say her partner, to buy an $800,000 house, then you might go on the title if you've given them 200 as to 25% as a tenant in common in an unequal share with them at 75%. That is watertight. Now, we're not so naive. That's us as family lawyers with our family law hat on. But the financial advisors of the world would say, yes, but then that eliminates the opportunity for them to get the first homeowner buyer's entitlement. That creates state land tax for us because it's not our primary residence, and on it goes. But nevertheless, from a family law perspective, watertight. When they separate, if they separate, you're getting back your 25% value of the property the day they separate. So that's option 3, which is sometimes overlooked.
Yep.
It's a question of, I suppose, you've got to make up your mind. What do you want? What are you trying to achieve? Are you determined to protect your contribution, the money you're putting in, or are you happy to help out and risk it? Okay, so going on title is 100% crystal clear. You own a quarter of the property. It's yours. Nobody can touch it. The other way to do it is to do a loan agreement, put a caveat on,
Mortgage.
Whatever. That's pretty good, but it may not hold water depending upon which court it goes before. And you don't want to get involved in litigation where you're, as a parent, a third party in percentage between your son or daughter and their former spouse, right?
40 years, and we do about 1,500 cases a year as a firm. I reckon we've only ever seen 2 valid loan agreements. Because to be a valid loan agreement, it's got to look like a duck and quack like a duck. So it has to have 2 separate pieces, the advice given by the parents to the parents, separate advice to the kids. So separate lawyer, separate advice, and signing, of course. It's got to have the terms that are commercial terms. What's the interest? When is it repayable? We see that gives the right to a caveat or a mortgage. We see things that say, yes, repayable if you separate, repayable on call. That's not a loan, right? It's got to have repayments, and there's got to be evidence of repayments or regular repayments, just as a bank loan would, or alternatively payable in 2 years or 5 years, not if they separate, because that's not a loan.
Yeah, which in most cases, when people are thinking about passing on their wealth, that's, having the repayments probably isn't something that's what they wanted, or affordable or achievable. So
They're making a decision in happy days, and they want to help out, and everything's good and hunky dory. So therefore, people don't think commercially in those terms. But then when the relationship breaks down, that's when people start to question, hang on, I want my money back now. Or, I gave that, but it was for the benefit of my child only, right, not up for grabs by the ex-partner. But it's too late. You can't undo it. Because there's a presumption of law that if a parent gives money to a child, right, in a relationship, it's called a presumption. It's presumed that it's a gift, that it's presumed as a transfer to help them out, right? So then the person who wants to overturn that and say that no, it wasn't a gift, it was a loan, and it's got to come back as a debt, then they've got to call the evidence to establish that, and that's very hard to do retrospectively.
Yeah.
You've just got to do the right things to create the mortgage, etc. Or otherwise, as you pointed out, the binding financial agreement between the parties. So as Joe pointed out, you can have one prior to living together and one during the time you live together. I have never had one done during the relationship that has not resulted in the parties separating. They break up because one party wants a BFA during the relationship and the other party says, don't you trust me anymore? And they break up.
Yep, of course, and that's I guess one of the interesting things about prenups and binding financial agreements. It does kind of enter into this territory of the question mark on the relationship and how that kind of interacts and plays out. And I'm sure the other spouse doesn't always feel too good about it. But have you seen it done well? Is there cases where it's worked, it's done well, and it's served its purpose?
Yeah.
Yeah, there was a reported decision that I read just recently in Sydney where the parents wanted to downsize, and their son and the daughter and their children needed to upsize. So they basically swapped houses, but to make sure that their son ultimately got the benefit of the upsized waterfront house, they did proper commercial documents, proper commercial transactions, and a BFA, and it was all done rigid. They all went off to lawyers, got advice, signed it, and the court held, well, you got the benefit of the more valuable house, the bigger house during the term of the relationship, but it's clear what the intention was from these documents, and we're going to uphold the agreement as being valid. In that case, the wife was saying that the agreement wasn't valid because, we've got the house and it's our house and it should be our house now. But the court said no, it was pretty clear the intention was that it was to benefit their son and their son only, and the court upheld that.
Yeah.
So if it's done properly and it's given proper consideration, thought, proper legal advice, it can be documented so that it's crystal clear what's going to happen.
Yep. Really, really, really interesting, and thank you for touching upon the third one there. I guess it's something that we perhaps haven't come across too often, and like you said, it's because there are some downsides to it, and particularly when you're trying to help your children along, and it's usually to do with the house, then it kind of defeats the object of the concessions that people can otherwise get. So So thank you for sharing that information and context there. Is there anything else in that space that you wanted to add before I move on?
Let's talk about testamentary trusts, for
Mm.
your estate.
Mhm.
And so there's been a recent case where husband and wife separated. The husband was a beneficiary under his father's will of a testamentary trust, and the appointors and trustees of the trust were himself and his sister. And there were mirror testamentary trusts, so that neither the brother or the sister had full control. They both had equal control.
Mhm.
The wife of the husband argued, well, the assets in that testamentary trust should be included, because the sister, of course, could say that the husband should receive his assets now in one lump sum, etc. But the court did not uphold that view. The court said no, husband doesn't have full control or majority control. The testamentary trust was clearly set up during the father's lifetime, and he also had a letter of intention and wishes when the father created the testamentary trust that he was doing that to avoid any of his children losing their assets to their spouse in the event of a separation. And it was held that the assets in that testamentary trust would not be included in the matrimonial pool to be divided. So always remember, if you're setting up a testamentary trust, don't have one person, your one child, have two people, and so that no one has a majority control, and that way it will not be included in the family law settlement.
So just for our listeners then, just to kind of touch on what a testamentary trust is effectively the fourth option, which is when you have passed away and you have written within your will that upon your death there would be a testamentary trust that is established, and it has rules and provisions that are set around that, and it's effectively controlling beyond the grave to a certain extent is how I would understand it.
That's a great description. It's control beyond the grave. And so although earlier we said family trusts that are not part of a death testamentary trust are included in the asset pool, testamentary trusts are not, if done properly.
Yeah. Okay. Yeah. Could there be any issues there with having the two people having control of the testamentary, because that has its own dynamics, right? You may have a brother and sister that have equal control around the two separate trusts or the one trust, whatever it may be. But they can make decisions, and they may not get along and feel like they're entitled to. So everything seems to have this kind of deeper layer of, there's always a trade-off. There's no perfect way of doing this.
Consequence. Yeah, that's very true. There's always a trade-off, because there might be a time, there's no separation, but there might be a time when one sibling, for whatever reason, needs the assets now, and the other one says, no, it's tough titties, it's not going to happen.
Mhm.
So, everything has a consequence. Nothing is uncomplicated, is it?
Nope, certainly not in law. Okay, so let's think about then the concept of asset protection. So in the context of family law, and we're kind of already talking about it with the prenups and whatnot, but at what stage of life should people start thinking about asset protection? When do you commonly kind of see that play out? Is it at the pointy end where people go, oh no, all of a sudden I need to think about this, or
Too late.
but it's too late?
Well, they certainly think about it. I think, in my experience, they think about it at these points. If people are getting married somewhat older now than they used to be, so previous generations got married younger with nothing, right? They lived with their parents till they could save enough money to buy a house with nothing, and their parents often couldn't help them out. So now that people are getting married older, now that parents do want to help them out and pass on the wealth during their lifetime, it's occurring. The prenups are occurring prior to the first marriage, and they need to do it. Look, you wouldn't want to be signing a prenup less than 3 to 6 months before you're getting married.
The sooner, the more distant from the date of marriage.
The opinions of the presenters are objectively ascertainable and are not intended to be financial product or personal advice.
And it could be risky.
Well, it will be risky.
Yeah, so
like I've got one where she signed the BFA on the day of the wedding, in her wedding dress.
Wow.
Had her veil on, and I've got one that was signed 2 weeks before. That's really duress, right?
I would have thought minimum 3 months, probably 6 months or more.
So that's
Gosh, I wonder how you approach that conversation on your wedding day.
Yeah, I love you forever, but
Yeah. Wow.
Where I prepared the prenup for my client, and we've been negotiating for months in advance before they were getting married. They didn't live together, and on the Friday he said, send a letter to her lawyers. If the agreement's not on your desk signed by 3:00 this afternoon, I'm not turning up to get married tomorrow. I said, look, that's not going to hold anyway because it's duress. He said, do it anyway. I sent the letter off. I rang him Monday. No, the agreement never came. He didn't rock up.
Oh, it's terrible, isn't it?
Well, he had been married 3 times before.
Yeah.
And he said, I'm not doing it again.
And that was the next trigger point. There's a lot of, they often do it prior to their second marriage and prior to their third marriage, because they're protecting it for themselves to ensure that they don't have to divide it a third time, a fourth time, a second time.
And children.
And their children, and particularly children from separate relationships.
Yeah.
So our billowing and greatest growth of area of work is older couples, and I mean in their 70s, 80s and 90s, who are separating because they've got children from separate relationships, and they want to ensure those assets are protected in the event of first person dying.
Yep.
Not separation so much, death and separation, because one could go into a nursing home and they're separating. Yeah. So it's they certainly want to protect not just for themselves but for their children.
Yeah. So in most cases, in those sorts of situations, then Leanne and Joe, what would you kind of suggest as the first point of call? So they've come to you, they've gone, this is my 4th marriage, I'm kind of towards the end of my life at this point in time. What's your first sort of recommendation around what they do? Is it prenup or is it BFA?
Well, it's the same thing.
The same thing, yeah.
What's interesting, and you're not going to like this, it's distasteful, but the first thing I ask, and I don't know if you ask this, depending on their age, I'll say, what's the state of health of your partner, and is their death imminent for any reason I need to know, e.g. cancer, chronic illness, blah, blah. Because if I think there's a really strong chance they're going to outlive their partner, I might say do nothing and outlive them, and you'll get everything. That's my first point. If they're an older couple, I know it's distasteful. You don't do that, do you?
No.
Because you're much more polite than me. Okay. And then the next point of call will be to say, look, we can negotiate, but depending on your age and your state of health, my client, the problem is if you negotiate and you die during the negotiations, the other party's going to get everything. We need to get our foot in the family court. The minute you issue an application, other people, your children can step in your shoes to get a share. If you have not issued, then you're not going to get anything.
Oh, you're talking about in the context of a
Older.
separation.
Yes, I am.
I thought
Yeah,
that
yeah.
Kelsey was asking in the context of going into a relationship.
Oh,
Well,
okay.
both. We can do both. Yeah.
Yeah.
Obviously, I advise Leanne the same advice, Leanne, about if they're separating. If
Mm.
that's the case. Sorry, I thought you were talking about
Yeah.
entering into a relationship. If a client comes to me and says, "Look, I'm thinking of going into a relationship. I've got these assets. I want to protect them for my children. What do I need to do?" I'll obviously give them advice about, look, we need to negotiate a binding financial agreement. But don't forget, a binding financial agreement is an agreement. It needs to be agreed to.
Yeah.
So we'll go through what the different scenarios are, the different possibilities, and permutations of how that might look. And we will then do a letter to the fiance or partner, whatever that might be, and say, we represent so and so. We understand that you intend to marry. We want to do a binding financial agreement, and these are the terms. Please engage a lawyer, because both parties need lawyers,
Mhm.
so that we can narrow the issues in dispute, reach an agreement, and formalise a document. Right now, more often than not, the parties have spoken about it, and there'll be some negotiation to prepare a BFA. But if there's silence, then there's the other side have written back and said, "Oh, we don't want to do it." Like Leanne said, often that starts to create problems.
Yeah.
The relationship could break down because one party wants to protect their assets, the other one doesn't want to think of their relationship in those sort of terms, and that's the end of the discussion. I've had, like Leanne said, quite a number of clients who, at that point in time, the relationship's
It's over.
Yeah.
The bare bones, Kelsey, there are some bare bones. They're really the minimal sort of bare bones of a binding financial agreement. We call them pre-nups or binding financial agreements. It's interchangeable language. The bare bones are, if we separate, I will take away those assets I came in with. If we separate, I will take those assets purchased during the relationship, registered in my name. Bank accounts registered in my name, shares in my name, cars in my name, houses in my name. If the houses have been purchased during the relationship, but they're in my name, they become mine. And you schedule what you've got now. You specify anything during the relationship that's purchased but is in my name is mine. Anything we buy together will be divided if we separate based on how it's registered. 25% you, tenant in unequal shares, 75% you, or jointly 50-50. It'll have the mechanism for who buys who out, both want it, sworn valuation, both bid. It'll have protection of inheritances, and it will have sometimes mechanisms for what will happen in the event of children. Who will support who? Will it be staggered in terms of the support? So it's kind of morally, I think, fair, but it's somewhat different to entering into a marriage or relationship where you think you will be happy ever after and swings and roundabouts. It's not that. It's a very different perception.
I think it's an interesting concept, and I wonder if it does become a little bit more popular, because I think we have this new dynamic of couples where everyone has their own income and everybody has their own bank accounts, and everybody is very much then a lot of people are very much about this is mine, this is yours, and we come together on these things. So I wonder if that's something that we're going to see more of into the future, as in terms of income that's equaling out between the two genders, for example, and that changes things, that changes dynamics.
More often I'm seeing now that clients keep their finances separate from each other.
Yeah.
Particularly in second and subsequent relationships.
Yeah.
They have separate bank accounts. They might have one joint account.
Yeah.
And they each contribute $300 or $400 or $500 a week, and that meets their joint expenses. But otherwise, they use their income for their
separate things. Yeah.
Yeah.
But then that feeds into the myth, doesn't it? Because how many times do we speak to clients and they say, "What do you mean? What do you mean she gets my super? What do you mean he gets that car? What do you mean that gets put into it? We keep our finances separate." Yeah, but you're in a long relationship, and that doesn't matter. That's part of the minestrone of the soup you're all eating out of. And, we're not looking at who paid for one. How am I going to measure? I'll say to them, how are you going to measure who did the shopping and who did the cooking and who did most of the cleaning and who did this and who dropped off and picked up the kids? So it's the financial and non-financial contributions. And it doesn't matter that you kept them separate. That doesn't mean they'll be separate when you separate. That's
Yeah.
for sure.
And that leads me, yeah, and that leads me to another question in terms of, if somebody did get a binding financial agreement and then over time their situation has significantly changed, i.e., children come into the fold, marriages, change of employment, etc., are these things that should be revised, and can you revise them? Because I know with wills, for example, we might say, at least every 10 years revisit them, or when there's a significant change. Does that apply for binding financial agreements too?
You can. Obviously, a BFA can be terminated and a new BFA can be put in its place at any time. I think, though, the complexity becomes that once you've been in a relationship for 5, 10, 15, 20 years, then somebody's going to be probably disadvantaged by any change.
Mm.
Possibly. Firstly, secondly, when a BFA is done early on and the couple are relatively young, in other words, in their 20s or 30s, going into a relationship, and the relationship then goes for 30 years, well, there's so much water that's gone under the bridge with income earned, assets, like Leanne said, there'll be a schedule setting out the assets 30 years ago, but those assets have all been sold and monies have been mixed and new assets bought, children have been raised, it becomes more complex. So
Yeah.
when do you then revisit it to change it, and change it to what? Do a new schedule? But then becomes arguments that arise as to, oh yeah, well, we sold that property and bought another property, and one party put in money towards that property, or if they didn't put in money, they did something else. It becomes more complicated.
Yeah.
It becomes very difficult, what we call the vicissitudes of life, all those things that are unknown today that can happen into the future, such as, illnesses, change of employment, disability. Those things are very hard to take into account when you're looking that far down the track.
Yeah, of course. Yeah. No, it's definitely a really interesting topic area, and I'm glad we're having these conversations today, because I feel like we do have a lot of younger listeners. We have listeners from all age ranges, but I think it's a kind of new concept to introduce to people that may not be thinking about this, having some idea of what they want the outcomes to be, but not thinking about how they get there. So I think that's been a really good area to cover. And you'd mentioned earlier about trusts and how people sometimes go, well, I'm just going to put all the assets in a trust. You can't get them. Talk a little bit more about that.
So there is a really interesting myth and misconception out there amongst the general population, isn't there, Joe, that if you've got assets in a trust, they're somehow not caught by the family law asset pool.
Well, people often come from their accountants who have set up complicated trust structures with the belief that assets within a trust are separate to the individual and therefore they're protected in the event of a separation. But we know as family lawyers that's not necessarily the case.
Yeah, I think the accountant's view of it comes from the estate planning lens, because of course assets in the trust are not included in a will and don't form part of the normal probate in the estate. So they're right, the accountants are right from that perspective. And of course the asset protection, sorry, Joel, in relation to companies and trusts in terms of taxation, liquidation, etc. So of course it serves a really good purpose putting it in a trust. But for family law purposes, there's a very famous case called Ascot Investments, 1975 or 1976, which said,
well, that case says that if the controller of the trust is the same person as the beneficiary, then pretty much the assets of the trust belong to that person and they form part of the property pool like any other asset does. So assets in a trust might work for commercial purposes like taxation and asset protection purposes, but they won't necessarily work for family law protection purposes.
And what you're looking at is who is the puppeteer. So, of course, read the deed is the golden rule. Read the deed, that is the trust deed. But generally, assets in a trust, the appointer, etc., is either the spouse or one of them, and one of the beneficiaries is one of the spouses.
Yeah,
so they're in effect in control. They are the puppeteer of the trust. So bad news, folks. It's not going to be a mechanism with which to remove the assets from the division of the pool.
In the main, that's correct. And the first thing to do is to get a copy of the trust deed and have a look at it very carefully to see how the trust is set up, who the appointer is, who the trust is, and who the beneficiaries are. And it's then that we can give advice on individual cases.
Yes.
Now, what we usually see it kind of with trusts and companies in our field of work and thinking about asset protection is when we're working with solicitors and accountants, sometimes we do see that if you've got a beneficiary company, for example, you will see that the other spouse is the director, not the person that is the controlling. And yeah, so we do see that quite often. And how would that then come into play if those people were to separate?
So for the purpose of family law property settlements, it doesn't matter whose name entities are in. That is, whether it's real estate, directors of companies, shareholding in companies, appointors of trusts, trustees companies or trustees of trusts. Those sorts of technicalities aren't that important. It's more important as to who the owners and controllers are. And for the purposes of companies, if one party is a director or shareholder, it doesn't matter as long as it belongs to the parties or they've got an interest in that company and through shareholding, then it forms part of the property pool. That's the main crux of that issue.
So, look, in essence, people look at all various ways in which they can protect assets and exclude them from the asset pool. And really, the only way to do that is before you go in with a prenup or a BFA, or during the relationship with the protection of a binding financial agreement that quarantines a particular asset, or going on title in a particular way where you might be a tenant in common in an unequal share, or doing a loan agreement from parents to a child. If you're dealing with the bank of mum and dad, that is a genuine commercially viable loan agreement with repayments, with a payment date for the end, separated by two separate lawyers given advice and signed and secured by way of a mortgage and or a caveat. So other than that, everything's going to go in.
Pretty much, the court's got a very broad discretion to look at all the assets and take them into account to the extent that it needs to, unless there is a commercial reality where they're not owned or controlled by one or other of the parties. And like Nan said, if you're going to do a loan agreement, a lot of people do loan agreements, they don't get legal advice. And unfortunately, then when a relationship ends and they go see lawyers, they find out that the loan agreement is not valid and it doesn't protect them. So if people are going to lend their children money through the bank of mum and dad, they need to go and see a family lawyer to say, what are my options? What's the best way for me to protect my advance to my son or daughter, as the case may be? And what's the way that I can assure myself to get my money back in the event the relationship ends? And like Nan said, you can go on title. That's the best way you can secure your assets, or do a commercial loan agreement as if you're doing it with a third party, with proper structure, valid terms, comprehensive terms about repayments. And the best way to prove that it's a real loan in the event of separation is that there are repayments being made along the journey whilst the couple are together.
You can show that. Yeah.
If you can show that there's regular monthly repayments being made, they could be quarterly, then when the relationship breaks down, that's pretty good hard evidence that the relationship, that the parties intended that loan was repayable.
Yep. So not much other than that you can do.
Yeah. Yep, it's really interesting from a kind of a legal and legislative point of view. It seems that the family law section really is covering off on all bases. You can't hide anything. There's no loopholes. It is what it is. Whereas there's certainly other areas of tax law, for example. Not doing anything illegal, but there's kind of grey areas. But it seems like the family law part is very black and white in that sense. And what are some of the most compelling changes? I guess you guys have had long careers. What are the most compelling changes, I guess, that you've seen or come across over the years?
From my point of view, I think the most compelling change that I've seen is that way back when I started practicing family law, superannuation was not taken into account. Fathers in the main paid very little towards the children for their financial support, and domestic violence was pretty much ignored. So in the last 50 years, the Family Act has been in place. There's been monumental change in those fields where with the child support scheme, the non-resident parent who's now paying a proper level of child support.
And the government's collecting it.
And the government's collecting it if they opt into the scheme.
Yep.
Superannuation is definitely taken into account and split between separating couples. And domestic violence is now looked at very carefully by the court in relation to both parenting matters and property matters, particularly as a result of the changes made in June 2025 last year.
Yep. There are some pretty significant changes. And in fact, because we've been around for 4 decades, Joe, you sometimes forget those changes. For me, from my perspective, I think when I started, of course, 40 years ago, de facto relationships couldn't be dealt with in the family court. They had to be dealt with in the county court or Supreme Court. And we ran quite a few of those cases, and it was incredible injustice. For example, a de facto spouse could not claim spousal maintenance. They were certainly precluded from many things. So the couple of changes, or the changes I think were significant, was having de facto relationships recognised as a genuine relationship and dealt with in the same way as a married couple. B, the introduction of binding financial agreements, so that now you can have a prenuptial agreement or a binding financial agreement that says you can, and that was 2013, I think. Yeah, 2013. You can now quarantine assets and say, well, I will keep what I came into the relationship with because I've come in with a lot more, and you can keep what you've come into the relationship with, and whatever we buy together, we will share. I love that concept because people are getting married older or living together older. People are entering into 2 or 3 significant relationships in their lifetime, and why should they have to share their pie 2 and 3 times over, etc. And it also enables them to quarantine assets for their children, because often in a second and third relationship, they are not children of the relationship. They're children from previous relationships. So that's a fairly significant change. And as Joe said, I think taking domestic violence matters into property cases is really significant. Mind you, to date, there's not been one case where someone can afford to run that aspect, but wait and see and watch this space.
Yeah, look, I think there's probably lots of other areas that we could still talk to, and then that's around, the factor of, the child support, spouse maintenance, and all those things. And maybe we do come back together for another session, because I feel like, we're having some really good conversations, and I know that you've certainly got a lot to add in that space. So listeners, please let us know if there's anything else in addition to that you'd like us to come back together and talk to. But if there's one tip that you could leave our listeners with in this space, what would it be?
The one takeaway that I'd give to everyone from this is that the information that Leanne and I have shared today is of a general nature only, and obviously is not intended to be legal advice. Each individual case is unique, and each individual case should go
on its own merits, really.
Yeah, on its own merits, and people should get their own separate independent legal advice.
I like the plug of the disclaimer.
And certainly if you go to our website, you'll get all the information you need, and shortly we'll be uploading a whole heap of and a range of videos that you can watch as well. For me, the one tip I would say is choose your partner wisely. Better to be single than wish you were single. That's it.
Yeah, absolutely. And Joe, Leanne, thank you so much for coming on board and having these conversations. I've thoroughly enjoyed it, and I hope you listeners have too. And if you want to hear more and you like what we're talking about, please make sure that you subscribe, like our channel, leave us comments. We want to hear more from you, so make sure that you do so, and we'll see you back on the next episode.
The opinions of the presenters are objectively ascertainable and are not intended to be financial product or personal advice.